brilliant. So, good morning, afternoon, or evening, depending on which time zone you're in. It's a pleasure to welcome you to this meeting of the Junior Faculty Forum. Let me begin by introducing the people, the presenter and the discussants today, and then I'll give a very quick rundown on how this symposium works. So, the author of the paper we'll be discussing today is Rabiul, who is a doctoral researcher at City University, Hong Kong. He's published a number of papers looking at criminal law and constitutional law in Bangladesh, and he was awarded the Outstanding Academic Performance Award for research degree students by the City University last year. His paper today is going to be on judicial independence and the removal process of judges in the light of the 16th Amendment to the Constitution of Bangladesh. We have two discussants today. Our first discussant is Dr. Yasser Kureshi, who is currently the John and Daria Barry Postdoctoral Fellow in Constitutional Law and Constitutional Theory at Trinity College, Oxford. His work mostly involves the constitutional politics of unelected institution and post-authoritarian states, looking at the relationship, for example, between the judges and the military. And he's recently been looking at an idea of judicial populism. So we are, I'm sure, all looking forward to hearing his comments on the paper. Our second commentator today is Dr. Anna Jajit, who is an academic at the University of Melbourne, a postdoctoral fellow in the Laureate Program in Comparative Constitutional Law. Her work focuses on constitution making, constitution design, and legal pluralism. She's done a lot of work on foreign judges in national courts, which is, I think, anyone who works in the area knows that work. And once again, we're all looking forward very much to hearing what you have to say on the paper today. Before we get started, let me just say a couple of things about the format. It's fundamental to the Junior Faculty Forum that everyone comes in having read the paper. So unlike many other symposia, we don't start with a presentation of the paper. Instead, we give the author a few minutes to briefly set the context for the paper, perhaps what he's trying to achieve, perhaps what sort of outcome he wants it to have, what impact he wants it to have on the readership, but he doesn't summarize the paper. He sets a broader context. After a few minutes of context setting, the two discussants will then offer the comments on the paper, and we open up the floor to broader comments. There are a small number of rules in relation to broader comments. First, I would ask you to raise your hand either physically or virtually. Second, we are very keen that comments be constructive. The goal is to help the author make the paper the best paper it can be. So please participate in the discussions with a view to achieving that goal, putting the focus on helping the author improve the paper and make every possible change to the paper so that it can make its case as powerfully as possible. So with that out of the way, I will now ask Rabiul, the author of the paper, to just offer us a few words on the context for the paper and what it's trying to achieve.
Thank you, Professor Arvind. At the same time, just I'd like to thank Junior Faculty Forum, who have organized this session today. It's the real the sign and the reflection of the academic activism, what they are doing. Just it's really great. And my paper, basically based on the 16th Amendment to Bangladesh Constitution, and which is very over discussed and to some extent very impugned and controversial. Basically Bangladesh actually in the very original constitution of Bangladesh, when it was made in 1972, then actually it had the provision of judges removal by parliamentary regulation. But later on, I mean, Bangladesh actually has gone through different type of the martial law regimes. And so when the first martial law actually came into power, then they, I mean, changed the constitutional system and basically introduced the Supreme Judicial Council, and this thing actually later on, I mean, changed by the 16th Amendment. And when the, I mean, constitutional reform has been made by Bangladesh Parliament, then it was really the very tension time between the legislature as well as the, I mean, Bangladesh Supreme Court. So even you might be surprised by knowing that there was the direct tussle between the parliamentarians and the Chief Justice. And even the speaker had to give the ruling in order to resolve the crisis. And finally, it was, I mean, just stopped, but there was no, I mean, fruitful, I mean, like the harmonized relationship between them still. And you might be also, I mean, surprised by knowing that the judgment, I mean, this, I mean, amendment was subject to like judicial review, I mean, in Bangladesh Supreme Court, and the judgment was given in 2017, but unfortunately that judgment is still under the review petition, and that has not been decided for, I mean, almost 5 years, and that has been deliberately done by the ruling government. At the same time, you might be surprised by knowing that the Chief Justice, who basically, I mean, declared this constitutional amendment unconstitutional, that Chief Justice had to leave the country and he was forced to resign from his office. So now you are understanding the situation and the intention behind this type of the, I mean, the like the new reform, like to remove the judges by the parliamentarians. Yeah, right. That is the thing. And like I'm not pretty sure whether I will be, I mean, permitted more time or not, right? Can I just speak 2 minutes more?
Yeah, that's fine.
All right, thank you. And this, I mean, the reform is also controversial, I mean, in terms, in respect of Bangladesh, because, I mean, Bangladesh is a unitary state, right? So if we see, I mean, the countries which are basically practicing this type of the parliamentary regulation to remove the judges, I mean, they actually have the double filtering system, especially in their parliament, like the United States of America, Canada, like Australia, South Africa, all are bicameral legislature. So they can do that, I mean, very, very meticulously. And there is at least the check and balance. But you know that in Bangladesh, it is the very unitary state. So there is, parliament is very, I mean, unicameral. At the same time, there is the anti-defection law, which is called the, I mean, the anti-floor crossing law. So the parliamentarians who are being elected from one political party, they don't have any freedom to give the vote against their political party's mandate. So actually there is the ceiling on their, I mean, the freedom of expression during their parliamentarian functionalism. So, I mean, to many aspects, I mean, this reform basically conflicted with the constitutional setup as well as the, I mean, constitutionalism. At the same time, I mean, the code of conduct for the superior judges in Bangladesh, I mean, that is very backdated and very, very vague and very, very imprecise. So like they are saying about the independence, saying about freedom, but nothing is very precise. So I mean, because I was the former student of comparative constitutional law in Central European University. So my this research over there. So yeah, so now it is in your hands. Just give me the enlighten me, please. Yeah, thank you so much.
So I think I'll take the discussants start now, starting with Dr. Kureshi.
Hi. Hi, Rabiul, and nice to meet everyone. Thank you for having me to read and discuss this very interesting paper. And I learned a lot about the Bangladesh judiciary and the Supreme Court and the tactics that are being used by the ruling party in Bangladesh to undermine judicial independence and to ensure the judiciary's compliance. And I thought, Rabiul, you laid out the political context within which the 16th Amendment was passed really well in Bangladesh to give the parliament the power to remove judges. And in the context where one party commands an overwhelming majority, as you said, this effectively enables the party to remove any judges who fall out of favor. And I was really glad now that you brought up this example, because one thing I was thinking about was, it'd be really interesting to see how the one party, the Awami League, actually strong armed judges. And so the example you gave of how he was made to fled the country is a fascinating one. And I would say you should actually bring that into the paper at some point as well, because it really highlights the kind of stakes and tensions you're talking about. And what you talked about was how the government ran the 16th as a revival of sovereignty, whereas the judiciary saw it as an infringement on judicial independence. And you nicely provide this comparative international discussion of conventions in different states pertaining to the process of removing judges, right? And then you think about how this could apply to the context of Bangladesh. Now, I have some thoughts about how you can advance the paper and particularly structure the paper to bring together the two sections you have, right? So you have the one section about Bangladesh, which is the decision itself and the 16th Amendment itself, and then one section with the comparative discussion that you talked about. And I was thinking about how you could bring these two together really well, because I think you try to do that in the conclusion, but I would really take what you do in your conclusion and build it up to be the overall structure of your paper, which is, my reading was that the goal of the paper was to think through what would a process of removing judges look like in Bangladesh through a consideration of international standards and practices applied to the context of Bangladesh. And so if that is what you want to do, which I think you want is interesting, then perhaps you could move beyond simply considering different standards and methods across the world to actually clearly developing a structure of judicial removal that you think will work in the context of Bangladesh. And based on consideration of both the international models and the local context, explain why the model you propose would work, right? So that would be, so therefore what I think is the question, and I'd love to hear your thoughts on this in the discussion also, what do you think is the best system for managing the tenureship and security of tenure and removal of judges that is suited to Bangladesh's context, right? And why I think this is really interesting is because this is an important news story, right? So, you know, the examples you've given here in the comparative literature are from South Africa, from Canada, and these are examples of the context of removal of judges and management of security of tenure within the context of, established democracies, right? But the whole challenge the world faces today is one of the context of democratic backsliding, the rise of competitive authoritarian regimes, and Bangladesh exemplifies the kind of semi-authoritarian system that we see as characteristic of political systems around the world today. So figuring out and thinking up through processes of protecting courts in such contexts, right, and working out systems that protect the security of tenure of judges in a way that applies to contexts outside sort of established constitutional democracies would be very interesting and important and a useful contribution. So, and I think that would really bring out your voice as well in the paper. So I'd be curious to hear from in the discussion also how you see it coming together and how you would what kind of proposal you would have given Bangladesh's context and the standards you propose. Second, what I thought was really important here you mentioned that this judgment and the 16th Amendment has been discussed a lot. One of the things to keep in mind is that a lot of your readers, like me, Anna as well, are not as don't keep up as much with Bangladesh as maybe others. So I thought this was fascinating. And one thing I felt like I wanted to read more of is what was that 788-page judgment you talked about, where the courts pushed back against the 16th Amendment, right? I think that would be full of very interesting discussion of how the Bangladeshi judiciary understands judicial independence. What are its dynamics? What is its prerequisites? And what kind of judicial precedents have shaped the way in which the Bangladeshi judiciary understands this concept and where security of tenure fits in it? So I would have liked to hear more about about that 788-page judgment, right? What are they saying about security of tenure, judicial independence, etc., and how that fits into your story of contextualizing the way we think of security of tenure to the context of Bangladesh, right? So it was really interesting when you talked about how the government talks about reviving popular sovereignty, right? And I'd like to hear the dialogue between the courts and the judiciary more on these questions. But also, one interesting thing I was thinking about was this conversation about the Supreme Judicial Council, and this is something you could also maybe discuss. Is even while criticizing the weakening of the Supreme Judicial Council through the 16th Amendment, it's interesting to think about whether you think a Supreme Judicial Council is a good way to handle judicial misconduct, and if not, why not? And that when we just and why this maybe I was thinking about this was because one thing that's common across, I think, Bangladesh, possibly India, and certainly Pakistan, which is the jurisdiction I primarily work on, is the inordinate power that chief justices wield, particularly in the context of, you know, even the Supreme Judicial Council, right? The chief justice has a lot of power there, and it'd be interesting to know if that's the same in Bangladesh. And what happens then is that when you have the CJC and the appointment process placing a lot of power in the hands of a chief justice, then all the executive really needs to do to undermine the judiciary is not necessarily the Supreme Council, but just opt or control chief justice through informal means. And so that made me think, okay, whether we have a parliament that is in the hands of a powerful political leader like the political party, or a chief justice that is co-opted or controlled by the political party, the outcome is the same, right? Because either the parliament is removing judges who the government doesn't like, or a loyal ally chief justice is doing the same. So and therefore the question becomes about, is simply consolidating the power of removing judges in the hands of a Supreme Judicial Council really the way to secure judicial independence and security of tenure? Or do we have to think about the informal tactics that these such one-party systems or and powerful parties like the Awami League can use to undermine judicial independence and security of tenure, and thus think of a more innovative solution, maybe, which is something you discuss and consider in your comparative analysis to really securing the tenure of judges? And what would that look like? I also thought the discussion of floor crossing rules at different points was very interesting. And I think I needed a little more about how it would apply here, but it is very interesting. And what I felt was just missing a little bit in the paper, which I can see you have there, but I think you can bring it out more clearly. Sorry, there's a very loud horn over here. I hope it's not disturbing you. But in the debate between parliamentary discipline and of the discipline of the judiciary and judicial disciplining of the judiciary, what are the trade-offs between them, and what kind of solution could be best crafted for Bangladesh, in your opinion? And that brought me to one other thing. I thought the discussion of the ad hoc and the probation periods of judges is really interesting. Stylistically, I would bracket that as a separate discussion in the paper, separately from the discussion of removal of judges. And also, I think, to me, it's personally fascinating because this was a huge issue in the Pakistani courts. And one of the big judgments in 1996 in Pakistan was how to deal with the fact that Pakistan's military dictatorship used to use the sword of probationary status to keep judges in line. In fact, like under Ziaul Haq's regime in the 1980s, the chief justice wasn't granted security of tenure and was kept as an ad hoc probationary judge until 1 month before his retirement, right? Just to keep the pressure on him, right? And this is clearly a very fascinating tactic, and one that the Pakistani Supreme Court really reacted to strongly. And why I bring up the Pakistani court is because and this comes to another point I had, was when I read this, I thought so much of the comparative literature you look at is focused on states like South Africa and Canada, which is great. But those are also comparatively established constitutional democracies. But in India and Pakistan, you have very comparable states dealing with very similar challenges. Overreaching executives, powerful dominant political parties, powerful interventionist militaries, etc., infringing and encroaching in different ways on the judiciary, and the judiciary coming up with solutions to push back. So you have a really rich and interesting comparative literature within South Asia to address, to bring in, and to critique as well. And I think those could further illuminate the paper as well. So those were my thoughts about how to organize the paper to bring your voice out and your argument and contribution, and learning a little bit more, and I'd love to learn more from you, about the history of judicial removals in Bangladesh, like the removal of judges, like the one you just discussed right now, and informal pressures on the judiciary, and the relationship between the Chief Justice and the government. So yeah, I leave it there. I let but happy to come in further with any thoughts and anything I can clarify about what I said. But I enjoy the paper, and I think I'm really interested to learn more and see how you develop this very interesting topic of security of tenure of judges in this semi-authoritarian context that you speak of. And I think that has important generalizable and relevant implications for states beyond Bangladesh as well. Thank you.
Thank you very much for those very comments. I'm sure Rabiul will agree are incredibly useful. Before, I mean, I think we'll take comments from both commentators first before we then give Rabiul a chance to reflect on the comments. So I'll now hand over to Dr. Jajit for her comments.
Great, thank you so much, Arvind, and thank you to Swati and everyone at the Junior Faculty Forum for inviting me to participate. It's such a lovely supportive program for early career scholars, and I really thank Rabiul for sharing his paper as well. And I thank Yasser. Some of what he said is going to sound familiar and similar to some of the things I said. It's the curse of going second, but hopefully that just means you've got two minds coming from different parts of the comparative, constitutional, political, disciplinary divide, talking about some similar issues. So I hope that it's not too repetitive and still very useful for you, Rabiul. So we've been told to proceed on the basis that everyone's read the paper, but I do kind of find it helpful for my own thinking to briefly set out kind of what I think the argument is before just giving a few comments, which I think hopefully will help you as you develop the paper. But I think, like Yasser said, these are really interesting issues for conversation just in themselves. So the paper presents a detailed study of the removal provisions for judges under the Bangladesh Constitution. And for this, it seems to me that Bangladesh provides a super interesting case study because, as Rabiul outlines on page 11, Bangladesh has experimented with so many different models for the removal of Superior Court judges. So you've got the Independence Constitution of 1972, where removal is vested in the Parliament. You get it shifted over to the President. And then under martial law, this kind of committee of 3 judges, the Supreme Judicial Council, is given the power to discipline judges and recommend removal to the President. And then under the 16th Amendment, it all swings back to the Parliament again by 2/3 majority on grounds of proved misbehaviour or incapacity. So on its face, I think Bangladesh is a really kind of neat case study to explore the kind of pros and cons of each of these models. And while I take your point, Rabiul, that chopping and changing between all these different models is very disruptive and undesirable, I wonder if you can take advantage of this kind of history to more clearly set out each of these different models and what the pros and cons of them might be, while giving a kind of history or a context of Bangladesh. I think that would help me as an outsider to understand this history that you kind of gesture at, I think. But also, I think like Yasser, I'd be really interested to know if any of these removal procedures actually were used. I mean, it's often the case that they're not used, either because our judges are all very good or because executives and others find other ways to get rid of judges. And I know you mentioned that the Chief Justice was forced to resign, but that means that these provisions weren't used to remove that Chief Justice. So I think if there's any history of it ever being used, would be interesting, but also histories of it not being used and judges being removed in other ways would be super interesting to know. So that's kind of my first suggestion, is to consider a way to maybe step through in a more systematic way what each model was and how in practice it worked. And I think that this might also help you to draw out the argument of your paper through a comparison. And I'm just trying to explain why I think that that kind of scene setting might help you to do that. So the argument as I read it, and I think I read it slightly differently to Yasser, which is interesting, is I read it that the 16th Amendment, investing power to remove judges in the 2/3 majority of the Parliament, undermines judicial independence. That's what I took to be your core claim. Again, I might be wrong, but tell me and we can talk about it in discussion. And I think there's different ways that this argument might be made. And I think you set out to try and make it, but in 2 quite different ways. So one way is to say that this process doesn't conform with international standards and best practice. And the second way is to say that the 16th Amendment process is problematic in the context of Bangladesh. So the problem with the first approach is, and you note this in the paper, that it's quite a common way to remove judges across the common law world. It's certainly how it's done in Australia. And so taken in the abstract, it's quite a difficult argument, I think, to say that that process in itself, without more, kind of is contrary to judicial independence. I think that there's always things you can do to improve the process, and the paper canvasses some really interesting options to supplement this process and make it better. So things like the Commission of Inquiry process, you know, how do you prove misbehaviour? To have proved misbehaviour, you set up a separate commission to advise. Another would be your suggestion to maybe alter the anti-party hopping rules so that they don't apply when it comes to voting on a decision about removing a judge. Another would be the involvement of a more representative Judicial Services Commission in decisions regarding removal and so on. But on its face, there's nothing kind of theoretically wrong with removal by a supermajority of the Parliament on the grounds of proved misbehaviour or incapacity. So what this paper shows, and I think this is the super important point and really interesting point, is that the problems for judicial independence arise not because of non-compliance with international standards, but because of how the parliamentary system of government works or doesn't work in Bangladesh. So the fragility of the Westminster parliamentary system, the dominance of the executive, the way the government can easily command a 2/3 majority, the unicameral parliament, all of these things are what is the problem for judicial independence in Bangladesh. And I think making this kind of argument, you know, you really draw out a really important point in comparative constitutional methodology, that an assessment of the procedure for the removal of judges just can't be made in the absence or in isolation from all of that context. So I guess I would encourage you to maybe focus a little bit more on this contextual kind of argument and a little less on what the international standards say. They're always really quite general. They leave a lot of room for adaptation. There's something you can kind of hang a lot of stuff on. And I think if you can take a step back and go, well, what do first principles require us to think about if we want judicial independence in the first place? You know, we want to protect judges from improper influence in their decision making. And then you think about, well, what kind of improper influences are at play in Bangladesh? And how do we best protect the Bangladeshi judiciary here and now from those particular influences? And again, it goes to what Yasser was saying, that maybe you can build up an argument about what you think the best procedure could be in Bangladesh to protect judicial independence in the removal of judges. Another strand of the paper, which, like Yasser, again, I found really interesting as an outsider, was this idea of a panel of 3 judges exercising the power of removal. That was really unfamiliar to me. I know a little bit about the Indian process for selecting judges and how that's kind of tightly held by the court, but not about the removal. So I think that's quite an unusual process in global experience. I might be wrong. But it's also quite controversial. I was getting really kind of worried about it because it means that the final, you know, the last resort mechanism for judicial accountability is in the hands of the judiciary itself. And so you've got this process where, you know, you've got an accountability mechanism that doesn't have any resort to an outside external kind of viewpoint, it's internal. So it seems to me that that kind of procedure is open to misuse and abuse. So Yasser mentions, well, it's easy enough for the executive to interfere in that process because all they need to do is get to 2 of these 3 judges and then you've got executive interference. But it also seems to me that the judges themselves, you know, can be misusing or abusing this procedure. It doesn't take much imagination to kind of think of a situation in when judges might fail to act in a case of misbehaviour because they want to protect their colleague, they want to protect themselves and their own reputation, or alternatively, they misuse this power to get rid of people they don't like on the court and shape the composition to their own ends. So I think, and then another part of this story that I think is quite interesting, I'm not sure where it fits, is that this Supreme Judicial Council, as I understand it from your paper, is a product of martial law, right? So you've got this additional kind of weird taint that this system that, you know, that's introduced in circumstances of military rule might actually be better than one that's kind of introduced in a more democratic context. And I think that that's something to think through too. So I think that there's a really interesting argument to be drawn out here about the Supreme Judicial Council. And most criticism in the paper is reserved for removal by Parliament. But I think that more could be said about the pros and cons of this Supreme Judicial Council model. And even some more detail about how it works in practice would be really interesting. So who are these judges? Who decides which 3 judges sit in this council? Do they require special qualifications? What are their procedures? All of these things. And I think that giving that background context might be a way that you can then really analyse the pros and cons of these different models in the context of Bangladesh. So my final comment, and is kind of related, follows from that point, is that I'd encourage you to be a little clearer about the conclusions or the recommendations you make. So I think that the paper very clearly and very strongly says that there are problems with removal by legislation, removal by the legislature in Pakistan. Not in Pakistan, sorry, it's late for me. There are problems with removal by the parliament in Bangladesh with that kind of model that's working. But I think that you're a little less clear on how we should fix that. So you canvass a lot of potential options to either improve that parliamentary process, but then there's also a hint, well, maybe we should go back to what we had before and leave it with the court. And I think it would be kind of good to know where you sit on this kind of side of the fence. Do you think it's better to leave it with the parliament? Do you think taking it out of the hands of parliament entirely is the best option, or is there some sort of halfway house that we can come to? So they're my comments. They're very similar to some of the things Yasser said, for which I apologise. But thank you for such a thought-provoking paper, and I look forward to the discussion.
Many thanks to both people, to both Anna and Yasser for your comments. I think it's very useful. Tarun, did you have something to say before I gave Rabiul a few minutes to reflect, or I'll take a question straight after that then? Rabiul, if you want to reflect on those comments now, I think please feel free to take a few minutes to do so, to give us what your response or reflections on those comments.
Okay, thank you so much for your very, insightful comments on the paper. I'm glad that you have just, thoroughly read and understood, what kind of the things I would like to present and just inform the international audience. So my point is that, interestingly, it was the product of Bangladesh Parliament, the 16th Amendment. On the other hand, it has been completely nullified by Bangladesh, judiciary, by Supreme Court. So it is really now in the dilemma. It is in the there are the 2 parties, one judges, another is legislature. So they are just, confronting. There is a huge tussle, tension. And still, parliamentarians are just arguing that they are going back to the original content of Constitution. So it is the original constitutionalism argument in their side. On the other hand, the judges are saying that, okay, that is the best, the model, especially for the unitary government, the state or the parliamentarian system, especially when there is the huge, the problem of the democracy, when there is the electoral system problem, there is the monopolization of one political party in the parliament. So, there are really, the risk factors, just lying under the underneath of this type of the reform. My point was that just I would try, just many, the scholars, they had tried to criticize this, the constitutional amendment, but just I'd like to give the constitutional recourse according to the context of Bangladesh. And in that case, just I said that, okay, even the parliamentary removal system can sustain if some of the, the required constitutional changes, which are, badly needed. So if those can be provided, then even, the parliamentary removal system can work. But this argument was completely rejected by Bangladesh Supreme Court. So that is the problem. So they actually acted as like a partisan of the, so there is also the problem that how they have reacted to this thing. So they have just taken that very personally. So they are thinking, oh, the, parliament is just whipping us. So they are not supposed to do that. So on the other hand, parliament is saying that just we are the, like, though there is a constitutional supremacy, but the parliamentary sort of the informal parliamentary sovereignty is going on because one political party since 2000, the last 5 parliamentary regimes, they have the same practice of just holding, that is the problem in Bangladesh. So just I try to, just bring the, international standard and the practices of some of the developed democracies, because if I just look at Pakistan, of course, they are the neighboring nations. At the same time, they have the same kind of the context, in terms of the politics and in terms of their legal system. But point is that they have also done the same wrongs. If we just formally see that, and informally as well. So, of course, in this era of comparative constitutional, regime, so I should say, so we have to borrow this type of the things. And I think, yes, some of the developed and democratic practices can be also transplanted, because Bangladesh, not only Bangladesh, most of the common law countries in their constitutional regime, they have borrowed lot of the Western ideas and the frameworks and the structures. So I don't see any problem in case of borrowing that. But point is that how we can just maintain. Yes, Anna said that, yes, well, there is the thing, like most of the, the common law countries, they are practicing the parliamentary removal system. But my point is that sometimes it is not the, the straight way problem, rather it is a very critical problem. So, there is no wrong in case of just removing the judges by the parliament. But point is that what kind of the democracy, what kind of the context you have. So Bangladesh actually is confronting in that area. So that is the thing. And of course, just I will, take your note and I will try to develop it further. Thank you, Anna. Thank you, Yasser, for your very, the kind and insightful comments. And thank you, president of session, right? Thank you so much. Thank you, the chair.
Thanks very much, Rabiul. I think we'll now open up the floor to, we'll open up to questions from the floor, keeping in mind the two rules I set out at the start. So please keep your comments constructive, helpful, and oriented wholly towards making the paper the best it can be. Tarun.
Thanks very much, Arvind. So I think, Rabiul, you've received some fantastic comments from two very thoughtful people, and I'm sure that they will paper. So I'm not going to repeat some of the things they've said, but there is one point on which I disagree with both of them, and so I'll offer my views as well, and then you can do what you want. You have, two sets of comments suggesting opposite things, which is on the normative side, both Yasser and Anna have sort of nudged you to think about what is the solution. I would suggest the opposite. I would say, don't worry about the solution. I think that often, especially legal scholars, can be a little too quick to offer solutions, and I think it's a lot more important to understand the problem first, especially at a stage of scholarship which is relatively underdeveloped. You say that the issue has received a lot of attention, but not from scholars, or at least not the kind of attention that I would have expected such an important issue to have received. I haven't seen sort of done a serious academic work, and this is in some ways the burden of working in the legal academy in the subcontinent as well, that we have to do a lot of thick description even before we get to conceptual and analytic claims, let alone normative ones. So I would absolutely focus on that. In fact, I would say maybe even the normative bits you have in the paper, I would take them out and just leave it for somebody else or for future work to do. But just understand. So what I would suggest, what I would take very seriously, however, is the comment that Yasser, I think, made about the dominant party context of Bangladesh, and that makes and that is a comment about how you frame the facts, right? So the paper has to do something more than just giving the reader facts about a particular issue. So your original contribution can come in the form of thinking about what is that context where you have Awami League being a dominant political party? What does that do to an issue of judicial independence? And an excellent example of that kind of scholarship, I'm just posting in the chat, you can look up the link, is Sujit Chaudhry's early paper on the jurisprudence of the South African Constitutional Court in this kind of context. And again, he was saying how the court is crafting a jurisprudence that is best understood from the dominant party lens, because the ANC was a dominant party. And I think that'll make a very analytically sound paper, but I would keep the thick description, maybe even give even more context and use an analytic rather than normative frame. Thanks, Arvind.
Thanks very much for that, Tarun. And I think, Rabiul, you're seeing very different perspectives come. I think what that reflects in part is the fact that you can write a paper in many different ways. And there are advantages to both papers, but I would ask you to reflect very seriously on what Tarun said, because, as he pointed out, we do often feel we need to fix the problem. But sometimes the biggest contribution we can make is offering a deeper diagnosis of the problem. They're both very, very noble endeavors. And I think it's really worthwhile you thinking which of them would better meet your needs. Dinesh, I've seen your hand. I'm just going to quickly offer a one follow-up. I think what Tarun says about dominant party politics is very interesting, and Bangladesh, for much of its history, has had that. I mean, obviously, you had Ershad's, General Ershad's rule, in which it was the Jatiya party for the most part dominating everything. But there was also a very brief period of hyper-competitive politics between the BNP and the Awami League. And I think that period when there very clearly wasn't a dominant party, it would be interesting to look at that as a contrast and see, did that actually make any difference? Did having that period of very competitive electoral politics actually change something? That's, again, what thinking of in working through your diagnosis. Dinesha.
Thanks, Arvind. Please bear with me. I'm not going to switch my video on because I'm in a quite dark place and you're not really going to be able to see me clearly anyway. Sorry. Thanks, Rabiul, for your paper, and also thanks to Anna and Yasser for your great comments. And I wanted to share my, my responses as well. So I read this paper with a lot of interest because Sri Lanka had the same debate 2012 to about 2015, because Sri Lanka's Chief Justice was purportedly impeached. I won't go into why we say purportedly, but she was also impeached through the parliamentary process. Of course, we had a parliamentary select committee, but that whole incident and the discourses around that incident raise questions about the adequacy or the inadequacy of a parliamentary removal process. So if you wanted to read about another similar occurrence in the South Asian region, I just wanted to point you to in that direction. Just reading about what happened in Sri Lanka might also help you to think about your question and see it in a comparative angle. The other point that I wanted to make is that I can see that you're interested in examining the removal process, but I was wondering whether both in terms of engaging with your reader and also in terms of engaging with the sort of the current global discussions about the judiciary, whether you want to think about appointments and accountability of judges during office, and whether those two aspects could come into how you frame the question about removal. I'm not sure whether, and I'm not saying that this is how you need to frame the paper, but I think when we think about removal, having in mind the appointment and also their conduct and accountability during office could also help to understand and clarify the removal process. And the third and final point I wanted to make, and this has been already said, I'm only saying it because sometimes hearing it from different readers will again speak to you in different ways. So I wanted to hear your voice more in the paper. I felt like you were telling us a story, but I wasn't sure where you stood in that story, which position you took about the story that you were telling. So I would really encourage you to let your voice and your perspective define the paper. Thanks, Rabiul.
I mean, Rabiul, I think those are both excellent suggestions, and I think the point of doing a bit more reading about the impeachment of Chief Justice Bandaranaike in particular is a really good suggestion, because she was impeached after having ruled against the government on 2 cases. So there you see a direct issue of the use of the removal process because the government of the day disagrees with the substance of the decisions. So yes, I think that's a very good point, and it's certainly something that I think you'll find useful to reflect on. We seem to have a pause. Okay, Ashwini.
Oh, thank you. Yeah, so I really enjoy the paper. So I don't know more about the Article 96 of this constitution and how it works around it, and how the removal process works. But I saw in clause 3 of Article 96 there, I saw that there was this Parliament has the power to regulate this process, to give more, to elaborate more on how this misbehavior and capacity of judge would work. And I look for something, if if the Parliament has acted towards it. I did not find anything. So it was sort of a question whether there has been any activity towards this to sort of activate this clause, clause 3 of Article 96. And if there has been, if maybe that should also be, that could also be discussed in this paper. And that's all. Thank you.
Thanks very much, Ashwini. Yes, so you had your hand up briefly. Did you want to comment at this point?
I can come in, but I just wanted to make sure that if there's anybody else who wanted to come in who hasn't spoken, or if then I can come in after that. So I don't want to intrude on anybody else, if that's it.
Go on. After you comment, we'll just take a couple of minutes for Rabiul to reflect on all the comments he's received up to now, and then there may be further comments. So no, do make your comment.
Okay. I guess my comment really comes in on what I think what Tarun was saying, and I think on what Dinesh was saying as well. So Tarun is, I wanted to say that, Tarun was saying you should consider taking out the normative and not just necessarily trying to propose a solution. And I definitely agree with that as well. Like, in the sense that, to me, why I was proposing the normative way of framing the normative answer was good. I thought that was what you wanted to do in the paper. And if that was the case, then what Anna and I were proposing were different ways to think about framing that normative argument. However, I'm very sympathetic to the idea that you should not do the normative work and just do the story of telling why judicial independence, how the politics of security of tenure and removal of judges, how it works in a semi-authoritarian and dominant party context, and why international conventions and ideas about it do not apply to this context, right? And I think that's also a very good paper as well, right? So, but I think maybe where I was coming from, and maybe where Anna as well, was also because the discussion of a lot of international standards may have been pushing me to think that you wanted to make a normative argument as well, and Anna can maybe speak to that as well. But you have both options, but I'm always sympathetic to the more the kind of story that Tarun was telling as well, emphasizing as well. And I think what Dinesh also points out with the example of the Sri Lankan example, it seems like an excellent example. And I think that goes to the point maybe to think about is why looking at comparative cases in South Asia are useful for you, right? Even though, as I think you rightly said, that, these are countries where a lot of these efforts at judicial security have failed, but you also have courts that have been actively contemplating these issues for a very long time in ways that they are thinking about why international standards are or are not applying in our context, right? What is it about these different, and so that's why it makes it so useful for you not just to think about other cases in South Asia as standards, but to think about the conversation other states have had as conversations that are relevant and applicable to the one that you are looking at in Bangladesh, right? So if there's a conversation about the successful impeachment in Sri Lanka or 2 failed impeachments in the last 10 years in Pakistan through the Supreme Judicial Council, twice now the executive tried to get judges that didn't like removed, and twice they failed, once they succeeded. And so for the last 2 years, we've had a really interesting conversation about this whole, I would, Anna point out, accountability versus independence, and how Supreme Judicial Councils straddle the line between accountability and independence. And I think it would be really relevant for you to therefore see in India, Pakistan, Bangladesh, the conversation, if not the standards, and think about how Bangladesh contributes to that conversation as well. So just some thoughts there, yeah.
Thanks very much. Rabiul, do you want to take a few, do you have any thoughts you want to give in response to the many comments you've had?
I'm really glad that I have got, too many, comments, and just I am thinking, okay, that I have to just direct the paper according to the contextualized framework. What will talk about the problematic side more, than the normative side. So yeah, of course, even the normative side can be just, seasoned according to the particular situation or the particular demand, what Bangladesh actually needs according to its, constitutional backdrop. So yeah, I'm really thankful to you that this paper can be, module in that very way. But one point just I would like to add here, that is the judicial review, the process, that I have also suggested in my paper, that yes, that is also the international standard, but especially even the Venice Commission, even the IBA, which is the international soft law for, independence of judiciary, even they are also saying that judicial review should not be that much, applied, or should not be thought of against the ad hoc tribunal or against the parliamentary regulation system. They are very, very, saying that. They are saying that, okay, yeah, so, parliamentary removal can be exempted from the grip of the judicial review. But I have just brought this argument into my paper, that judicial review can be the another option in order to just, again, you might go back to the argument that, okay, so that might in the hands of the judiciary again, so there might be, again, there is the risk factor of, judicial nepotism or judicial, favorism to the colleagues of the judges who are dealing with the judicial review. But of course, that should not be the case always. So judicial review can be the option even against the parliamentary regulation system, because when the constitutional amendment can be subjected to judicial review or constitutional review, so why that type of the decision of the parliament should not be brought under this scheme? So that is also my argument, that but again, so this normative, the discussion can be again linked with the context in Bangladesh, right? Thank you so much.
Thanks, Rabiul. Tarun.
Yeah, just a small amendment again to echo the point about South-South comparison. I think it's really important to avoid knee-jerk comparativism, which is especially, students from jurisdictions in the global South who are often doing their masters or their PhDs in areas of global power with a lot of soft power as well, end up just looking at Europe and the US for comparative insights for no good reason, that they accept that their scholarship is much more readily available and much more accessible, and their tutors teach that, and their professors know that scholarship. And I think that what some of your discussants have been telling you is that the inquiry will be much more fruitful if you focus on, I would say not even India, because India does not so far have a history of attempts to impeach judges because of their political judgments. There have been, of course, a history of not elevating a judge to the Chief Justiceship because of that, and there have been attempts of soft capture and blackmail and things like that. But you know, the formal route of impeachment has not really been used in India for a political disagreement with the judgment. So I don't think India is a good comparator either. But you need to think about why you're comparing with a particular case. And I think what you've been told about Sri Lanka and Pakistan is a successful impeachment and two unsuccessful ones for political reasons, for partisan political reasons, I should add, because you know, political reasons can be broader than that, by a dominant party. Or at least, I don't know if each case was a dominant party. Maybe it failed in Pakistan because there wasn't a dominant party. I don't know. But, you know, things like that, it'll just add to your dominant party context, which is not available in much of Europe or in the US. So I just think that it'll make a much richer analytic paper, which is why I just wanted to step in and emphasize that South-South comparison idea. Thanks.
Yeah, I do take that seriously. There has been work done recently on the importance of South-South comparisons. In a sense, when we are looking at North-South comparisons, there's a sense in which we're transplanting rules from one political context to a very different institutional context. And there are always challenges with what happens at legal transplants of the type. So it's definitely worth looking harder at South-South comparisons. Are there any other questions from the floor? Right, Rabiul, did you have any final thoughts to offer? Just an opportunity, no compulsion.
Okay. One thing is that in Bangladesh, actually, the different kinds of the removal system is still going on, but those all are informal. I mean, the either Supreme Judicial Council or the parliamentary proceedings, nothing actually have been experimented ever in Bangladesh. One case was just only done by Supreme Judicial Council, but all the judges removal have been done very informally. Even sometimes that was the very implied, intervention of the executive, and that included the last time removal of Bangladesh Chief Justice, Surendra Kumar Sinha. So he had to not only, just resign from his office, at the same time he had to be deported from Bangladesh, and now he is in exile in the United States. Anyway, the point is that Bangladesh actually, installed the mechanism. I don't know how much actually the politicians are interested to bring that type of the content just for removing, rather for, insulating the paranoid situation for the judges. So that might be another alarming thing. So of course, so this type of the alarming situation should be academically contextualized, and just I have to take up the dominant party arguments in order to develop the storytelling of my problematic framework of my paper. Right. Thank you so much. Thank you. Thank you for everyone. Thank you who have commented so far. Thank you.
Thanks, Rabiul. Anna.
Are we out of time? I can hold my comment.
No, don't worry. We have a few minutes more.
Okay, that's okay. I just wanted to just pick up a couple of other things from Rabiul's paper, and I take and agree with Tarun and Yasser's point. Right, if you want to do a thick description paper, there's huge value in that, and I think that that's wonderful. But if you keep talking about, judicial review of decisions and things, I keep getting a sense that you want to engage with the policy of this, to really be a problem solver. So the question then is the one Tarun put to you, right? You know, do you do one paper in one way and then a second paper in a policy way? And I think that's completely up to you, and I think both would be really excellent. If you're going to go down the policy path, I just encourage you to think of a couple of things. So the judicial review proposal is interesting, and I know that you cite the Venice Commission on this, and I haven't read what they have to say, but it seems to me judicial review of the merits of a decision like that is kind of problematic. Like, I can see why you'd want judicial review of the procedures and whether the procedures were complied with. But if the judge is essentially making that same decision again with the facts in front of them, then I think you've got, you know, two decision makers being set up there, and it might just not be a great policy choice, particularly in Bangladesh, where you've already got a lot of competition between those two branches already. So just giving it the same power to both doesn't seem to me to be a way to resolve it. Another part of your paper that I found really interesting, and I just wanted to put it out there just so you know that I thought about it, was where you talk about the relationship between a code of conduct and the process for removal. And I think that's a really important point, because, you know, how do you define what misbehaviour is? One way to define what misbehaviour is to set it out in a code of conduct that judges must comply with, and then you've at least got a agreed standard to assess conduct against. And is it, you know, is it misbehaviour of a kind that's serious enough for removal, or is it just disciplinary and all of that kind of stuff? So if you're going to go down that policy path and think about that sort of policy, I would encourage you to think about who makes this code of conduct and who enforces it. So is it going to be made by the Parliament or by the courts or by some combination of the two? And again, who enforces it? Is it the court itself? Is it an outside one? And these are all the kinds of policy questions that these kind of questions raise. Again, might be why you've got not just one paper, but two to separate out. So just wanted to put my 2 cents in on those. Thanks, Arvind.
Thanks very much, Anna. Are there any Yasser, did you have any final comments? No. Great. If there are no further questions, I think we can wrap this up for today. So much on leading academics giving up their time to read and comment on our participants' papers. So it's very, very deeply appreciated. I mean, we know how many calls you all have on your time, so it's very deeply appreciated. And Rabiul, thank you for putting your paper forward and for presenting it. I think it's been a fascinating topic. We've all learned a lot today. Thank you for doing this. And thank you all to everyone who attended and asked questions. And finally, I should also say a huge thanks to the conveners of the Junior Faculty Forum for actually taking the time to set this up. And there's a vast amount of work that goes on behind the scenes to make this happen. So could I just say a huge word of thanks to Animesh, Swati, and Tavni for everything they do on this. So thank you.